Judgment in the appeal to Globalia Business and Fulton's Shipping Incorporated.
Lord Clerk will explain the judgment of the court.
On the 4th of March 2005, the appellant owners bought a cruise ship called the New Flamenco. The vessel had been chartered to the respondent, the charterers, by its previous owners by way of a time charter party. By a novation agreement, the appellant assumed the rights and liabilities of the previous owners under the charter party, effective as from the 7th of March 2005. In August 2005, the owners and the charterers concluded an agreement extending the charter party for 2 years, so that it was due to expire on the 28th of October 2007. At a meeting on the 8th of June 2007, the owners and charterers reached an oral agreement extending the charter party for a further 2 years, expiring on the 2nd of November 2009. The charterers disputed having made the agreement and maintained that they were entitled to redeliver the vessel on the 28th of October 2007. The owners treated the charterers as in anticipatory repudiatory breach of the charter party and accepted the breach as terminating the charter party. The vessel was redelivered on the 28th October 2007. Shortly before the redelivery, the owners agreed to sell the vessel to a third party for $23,765,000 United States dollars. The owners commenced arbitration in London under the charter party, seeking damages for the charterer's repudiatory breach. The arbitrator found that an oral contract to extend the charter party had been made, that the charterers were in repudiatory breach of that contract, and therefore that the owners were entitled to terminate the charter party. These findings were unchallenged. However, there was a significant difference between the value of the vessel when the owners sold it and its value in November 2009, which was found by the arbitrator to be $7 million United States dollars, when the vessel would have been redelivered to the owners had the charterers not been in breach. The arbitrator declared that the charterers were entitled to a credit for this difference in value, amounting to €11,251,677, which was the equivalent of $16,765,000 United States dollars. This was more than the owner's loss of profit claim and would result in the owners recovering no damages. The owners appealed to the High Court pursuant to Section 69 of the Arbitration Act 1996 on a question of law, namely, whether when assessing the owner's damages for loss of profits, the charterers were entitled to take into account, as diminishing the loss, the drop in the capital value of the vessel. Mr. Justice Popperwell held that they were not, because the benefit accruing to the owners from the sale of the vessel in October 2007 instead of November 2009 was not legally caused by the breach. The charterers appealed to the Court of Appeal. The appeal was allowed on the basis that the owners took a decision to mitigate their loss by selling the vessel in October 2007, and there was no reason why the benefit secured by doing this should not be brought into account, in the same way that benefits secured by spot chartering a vessel during an unexpired term of the charter party would be. The Supreme Court unanimously allows the owner's appeal to this court in a judgment which I prepared. The reasons are shortly these. The fall in the value of the vessel is irrelevant because the owner's interest in the capital value of the vessel had nothing to do with the interest injured by the charterer's repudiation of the charter party. This is not because the benefit must be the same kind as the loss caused by the wrongdoer, but because the benefit was not caused either by the breach of the charter party or by a successful act of mitigation. The repudiation resulted in a prospective loss of income for a period of about 2 years. However, there was nothing about the premature termination of the charter party which made it necessary to sell the vessel at any particular time or at all. It could have been sold during the term of the charter party. When to sell the vessel was a commercial decision made at the owner's own risk. The owners would not have been able to claim the difference in the market value of the vessel if the market value had risen between the sale in 2007 and the time the charter party would have terminated in 2009. The premature termination of the charter party was at the most the occasion for selling the vessel, but was not the legal cause of it. There is equally no reason to assume that the relevant comparator is a sale in November 2009. There is no reason why a sale would necessarily have followed the lawful redelivery at the end of the charter party term. For the same reasons, the sale of the ship was not, on the face of it, an act of successful mitigation. If there had been an available charter market, the loss would have been the difference between the actual charter party rate and the assumed substitute contract rate. Sale of the vessel would have been irrelevant. In the absence of an available market, the measure of the loss is the difference between the contract rate and what was or ought reasonably to have been earned from employment of the vessel. The relevant mitigation in that context is the acquisition of an alternative income stream to the income stream under the original charter party. The sale of the vessel was not itself an act of mitigation because it was incapable of mitigating the loss of the income stream. Mr. Justice Popplewell was therefore correct to hold that the arbitrator erred in principle. The Supreme Court prefers his conclusion to that of the Court of Appeal. His order, setting aside the part of the arbitral award that declared that the charterers were entitled to the credit in respect of the benefit that accrued to the owners when they sold the vessel in October 27 as opposed to November 29, is accordingly restored.